Oh, hey guys. So I did actually see this filing hit the Texas docket very quickly after Judge Liman's order on Section 47.1. But honestly, I was so exhausted. I don't think I could have said any more after 2 hours of reading that order. But yeah, and then there was just one thing after the other. So I'm now able to get to it. Both Charles Babcock and Michael Gottlieb have actually filed in response in Texas. So I'm going to start with Gottlieb's actually. So notice of supplemental authority regarding defendant's motion for costs and attorney's fees. Defendant Blake Lively respectfully submits this notice of supplemental authority to alert the court to highly pertinent supplemental authority. Judge Liman's decision awarding attorney's fees to Miss Lively under Section 47.1 in Wayfarer v. Lively. In that opinion, Judge Liman held that Section 47.1 mandates a fee award to a prevailing defendant even where a court dismisses the defamation claims on grounds other than the Section 47.1 privilege, and before making any factual findings on the merits of the claim. I don't love that. I really don't. I don't love that. I don't think any part of Section 47.1 should apply before making any factual findings on the merits of the claim. I'm sorry. I just don't think it should. I also don't think that it should apply on any old ground for dismissal either. Because, in this case, in particular, in Jed Wallace's case, the case was dismissed for lack of personal jurisdiction over Lively. It was dismissed without prejudice, so she can go and refile. So I wouldn't call that prevailing. It's just the court saying you brought it to the wrong place. I don't see that as, I don't feel like she's prevailing in that sense. I don't know. It's just my opinion. I just think it's so they've attached a copy of the opinion as Exhibit 1, which I am obviously not going to go and read again. Judge Liman's decision is relevant to numerous issues raised by the parties in connection with Miss Lively's pending motion for attorney's fees. For example, the opinion holds that Section 47.1 creates a substantive right to attorney's fees that is available in federal court. The opinion distinguishes anti-SLAPP statutes that require application of conflicting state procedural rules, requiring that Section 47.1 may apply in federal court because awarding fees does not require the court to apply any conflicting state procedural rule. Nonetheless, the opinion finds analogy to California's anti-SLAPP statute for the purposes of evaluating who is a prevailing defendant. The opinion holds that California law applies to Miss Lively's fee-shifting claim because it applied to the underlying defamation claim. Right. To be clear here, now this is where there is a massive difference, was Section 47.1 in New York against the Wayfarer parties, right? That was on the basis of a complaint, Wayfarer's complaint, which included defamation against Lively, where they requested that California law apply, and Judge Liman applied California law in his dismissal, right? Here, there is no mention of California, right? Well, there is. Lively's, that was her reason for arguing that she should be dismissed was, well, Texas law doesn't apply to me. And, her argument that was that Texas shouldn't have jurisdiction over Jed Wallace and Street either, because Street was once incorporated in California. Brian Friedman is, who once represented Jed Wallace and Street, is a California lawyer. There really was next to nothing, but Lively wasn't asking for California law to apply. Particularly, she was just sort of making the argument that, well, Texas law doesn't apply to me, which they agreed with, but there's no ruling, there's no precedent set that California law applied to Jed Wallace. So, and the fact that it was applied in New York, but not against Jed Wallace, is, I don't think that's relevant. The opinion holds that a defendant is a prevailing defendant and is entitled to fees under Section 47.1, regardless of the grounds of dismissal. The opinion holds that under California law, a defamation plaintiff bears the burden to establish malice at every stage of the litigation and must ultimately prove malice at trial to avoid application of the Section 47.1 fee shifting right. Even sufficiently alleging malice is insufficient to avoid fee shifting if the plaintiff does not ultimately prevail at trial. Section 47.1's reasonable basis requirement requires only that a defendant show that the information that the information contained within the allegedly defamatory statement be the kind for which it would be reasonable to file a complaint. It does not require defendants to prove that their account of events occurred and that the plaintiffs did not. Okay, so that sounded a little bit like Gottlieb was saying, the reasonable basis requirement requires that we only show that the kind of information would be the kind that would be reasonable to file a complaint. It does not show that it does not require us to prove that it actually happened, though. That's risky for Gottlieb to suggest that, I think, because it's kind of skirting on the, well, we only needed to sort of like prove that Lively had a reason to complain because of the nature of what she was alleging. We don't actually have to prove that it happened, though, is what I'm getting from that. So that's from Lively's side, and we have got Babcock's, much briefer for now. Dear Judges Ezra with a Z and Howell, we write to make you aware of an opinion and order entered this morning in Lively. It was actually in Wayfarer v. Lively, not what Lively v. Wayfarer, technically. The decision concerns an issue similar, but with some important differences, yes, to Ms. Lively's motion pending before this court. We are still digesting Judge Liman's 47-page opinion, but as it decides a matter of first impression under the same novel statute before this court, the plaintiffs want to immediately advise you of 1, its existence, and 2, that they may seek to supplement the record, including without limitation, whether the order is applicable in whole or in part to this case. Thank you, as always, for your consideration. So that is an indication from Charles Babcock that, he's basically just simply saying, Judge, here is an order. But I'm getting the impression that he is going to be following up and, supplemental briefing will follow to say all the reasons why this order should not be followed. And it is not binding on the court. So Texas does not have to follow Judge Liman's rationale and reasoning here. They can, that it may be persuasive. They may look at it, to consider it, and decide to go, no, we don't feel the same, or the facts based on what's happened in New York with the parties that are currently in New York do not apply here, and these are the reasons why, which Babcock is going to argue for. So I'm looking forward to seeing what Charles Babcock says on this. I'm also seeing, as predicted, Lively took a victory lap. We're not shocked at this point. I just want to kind of throw my viewpoint out there on that, right? Lively did no better than I am predicting the New York Times to do. I've said that I think the New York Times will get their fees, right, under the anti-SLAPP law case that they brought against Wayfarer. I do think that they will be awarded the attorney's fees. That's that. They're seeking, I think, around $150,000 for defending for the same thing that Lively defended, the same complaint. So I cannot see how Lively is going to get to millions, because the New York Times are only looking for $150,000 for filing a motion to dismiss the same complaint that Lively filed a motion to dismiss. And the New York Times motion to dismiss, I remember when I read it, I was incredibly impressed with it. It was very detailed, but they also, they put in so much work, and it was very, very technical as well. Like, yeah, it was absolutely worth $150,000 in my opinion. I keep hearing Lively's going to be getting millions. No, she's not, actually. She is not. And there's a key difference here, right? She only had one motion to dismiss to file in New York from Wayfarer's complaint, because they amended their complaint before any motions to dismiss were filed. So, but here, I mean, she's only seeking I say only, it's a lot of money. She's seeking $800,000 from Jed Wallace for her, motion to dismiss his complaint. But she had to file two, because after they briefed the first motion to dismiss, Wallace then amended his complaint, and they had to do the whole process again. And she would be entitled, in my opinion, to both if she is successful. If because that is part of the successful defense. You still incurred a cost. Where it wasn't her choice to amend the complaint and then cause the whole process to have to be restarted again. And if she genuinely wins attorney's fees, then as I would say with anyone, they should not have to bear the cost twice if they've had to file two motions to dismiss. It would be, I think, unfair to only award her one set of those fees. So I think she'll get two, but still, she's done double the amount of work that she did in New York, and she's still not even seeking $1 million for it in Texas. So I don't know. I'm looking forward to seeing what the fee arguments are, and seeing the breakdown of all the costs. And there will be a fight, and I'm sure she will try to say, well, there was so much overlap between my case and Wayfarer's case, it's impossible. But we'll pick that apart when it arrives. But this argument that she's going to get millions, no, she's not. Also, I hate this narrative that she's won. I really do, because she has literally, to me, what Judge Liman has essentially awarded her is a dressed up version of anti-SLAPP fees. That's it. That is all he has done. So she is going to achieve nothing more than the New York Times are going to achieve at all. Like, the statute, if we look at the purpose of section 47.1, right, it is to punish and to deter, right? Now, attorney's fees, the possibility of being awarded attorney's fees for a defamation case, that doesn't generally deter anyone. That's why there are people who still, they include defamation in their complaint, and they take the risk that anti-SLAPP might apply. Where section 47.1 was so terrifying, I guess, is that it was the thought of the damages times 3, and then throwing on top punitive damages, which could have gone into the tens of millions. It could have really been huge in this case. None of that was awarded. All the elements that were intended to deter and punish abusers, that made section 47.1 so unique, were not applied to Lively. So no, I don't see how they can claim a win. She could have gone for those fees regardless for the defamation claim being thrown out, as Leslie Sloan did. Ryan Reynolds could have. And Lively still has not achieved, through Section 47.1, she has still not achieved any more than they could have achieved, than the New York Times has, is attempting to achieve. She is achieving nothing more. So the only she's just leaning into the fact that the award is under Section 47.1. And I just think that's just, it's so gross, because this is not what Section 47.1 was intended for. Yeah, I don't know. I've got some thoughts, I guess. I think I feel uncomfortable about the way it's all being played out. Not surprised, but uncomfortable. Anyway, so we will see how this all plans out. All right, guys. Thank you.